don't like that, right?
Hmm.
Some drama.
Does that make me the restless?
Possibly.
Hmm.
People gonna be like, Nate starts the damn stream off with this badass joke. I'm sorry, people. I'm sorry. It's early in the morning. What can you do? So we've been following this Rekieta case for a little minute now. How do you think things are? What's your assessment of where the case stands right now?
Things are not going great for Nick, is my assessment. The labs came back. We know that because they were disclosed to the defendant, although we don't know what they were. But the labs came back, and we can presume that the labs came back confirming some kind of drugs, because otherwise it would probably be a really easy motion to dismiss. Like, well, they're not drugs, so we all go home. So we have pretty solid inferential evidence that the labs came back positive for cocaine, perhaps, and some additional drugs, which might lead to new exciting charges down the line. And on the should we get rid of this? Should we suppress the search? Things could be going better. I don't have a lot of high hopes for it. I thought the state's response was about right, and things are not heading in a positive direction. How do you think they're going?
I don't know. My assessment of the case is essentially mirroring yours. What's up, Sakib? But the only thing I would say is that I think everybody has to understand this is an all or nothing for Nick when it comes to
pretty much.
The search warrant, because there was coke in his house. There's coke in his house. So if the search warrant's bad, the coke and all other bad stuff goes away. The search warrant is good, then this is really like what, 3-4 witness case, right? They just the cops,
It's two.
the body cam.
You need a cop with the body cam, so that's one, and you need the lab tech. That's two. Anything else is bonus.
And then the guns, you get the guns for free and the child neglect
because
you got the coke.
Yeah. And which also incidentally goes to this idea about Aaron Imholtz's potential issues down the road for himself. Aaron is a nice to have if you're the state for Nick's case, but not necessary. Because all you really need is the cop say, yes, I found the drugs, and you need the lab to say, yes, they are drugs. Anyone else is bonus. So Aaron Imholtz's problems relating to his own felony charges, if I'm the state, ultimately, I'm like, I don't even need to put him on the stand, so it's a non-issue. It's fine.
But let's keep it real. The reason why they're going, like, the reason why Aaron, they reported all that stuff to Aaron, let's just just be clear. Nick believes that was going to help his case against the state. I think in the grand scheme of things, because Aaron is a witness against Nick, and I think if they go to trial, just in case, they might want to bring Aaron on to have a little background. Hey, you were in the house, you were using coke, then let's destroy his credibility so you can't call him. So I think that's.
If I'm the state, if I'm the state, I'd love to have a witness that be like, yes, I saw him use drugs in the house, and yes, I saw him personally, with his own hands, put the drugs in the safe and so forth. That's great. That's a nice to have. So if I could put someone like Aaron or April on the stand, that's nice, but not required.
Oh yeah, this is funny. Anna Kasperi from the YouTube from
I saw that. I saw that clip. Anna apparently is following this story. She mentioned Sean, potentially criminal by name. Neither you nor I, though, so we're not getting any love.
It's okay. It's okay. We're not as compelling as those guys. So
that's all right.
So we know this for Nick. This is an all or nothing. So if Nick loses this,
it's over.
He's pleading. He's pleading, people. And I know people, oh my God, he's pleading. Now, also, too, Barnes was making a big deal about the kids, about the kid who had cocaine, tested positive for cocaine. We've heard no follow-ups on that, right? If that was if that test was a negative test, Nick would have been screaming, told you it was a false positive. Ain't nobody saying.
Yeah, I mean that case at the moment, of course, is a separate case. At the moment, that's a child custody issue, so that's under its own set of rules and under its own set of problems. And we don't really know much about that case. We do know from the original report that there was a test of positive on the hair, but there was no there's nothing in that report that said there was a confirmation test done.
Yes,
and also didn't provide any details about how that was confirmed.
Correct.
So it's possible that it didn't get confirmed, or it's possible that somehow else it's been satisfied. So whether or not the kid had drugs in his hair is a independent issue from whether or not there are drugs in the house.
Yeah, and I also think because there's some people saying that it came back the kid didn't have drugs in the system, and people are saying that the kids did. But I'm just saying, as of right now, the only test I
Yeah.
have is that test they gave that said the kid had a moderate level of cocaine in their system that was
Well,
indicative
they
of
ran out of numbers,
particular
Nate.
use.
It's
Yeah.
like we stopped testing at 5,000. That was we went past our limit.
Yeah. So, oh, we got our first super chat. Hi, Nate. Nice to see you streaming together. Oh, thank you, thank you, thank you. We decided that today we would take a different tack to this and just look at the legal aspect of it and not try to to spin it like some of our colleagues are doing, because obviously there's friendships involved and people want things to say certain things, but it just is what it is. Let's start with I started by saying, okay, let me get everyone, let's help everybody understand where we're at, what we're doing, and kind of where the case is right now. So I put together this little document just to get, before we go into Nick's document, this document just so we can understand where we're at
It's almost
now
like you've been a law
with the law.
professor before.
Yeah, well, I try. So here's the document here. And the first thing is that we're going to talk about the issue that Nick has raised. Now, before we get into this, just to let everybody knows how we got here. Nick Rekieta, he was raided by the cops. He had a whole bunch of cocaine in his house. They got the cocaine.
26 grams and change.
Yeah, so it was second-degree felony weight. The next thing you know, after they grabbed the coke, they found some guns. Now, if you got coke, you can't have guns. Then you have a child endangerment charge too, because you got 5 kids or 4 kids with cocaine and guns. It's just a nightmare scenario. So he gets charged, and he files a motion to dismiss. He's actually filing. It wasn't really a motion to dismiss. It was like a whole bunch of motions, right? There's a motion to eliminate, a motion to suppress. It was a whole bunch of motions, but essentially, Nick was asking the court to throw out the search warrant. Now, why is that important? Because if Nick is able to successfully argue that the search warrant is invalid, then all the evidence derived from that search warrant, usually you hear the term fruit of the poisonous tree, all the evidence derived from that search warrant would also be inadmissible because it's a bad search warrant. So Nick is now attacking the underlying search warrant. Now, the reason why I and so does and Kurt also believe that it's extremely important that Nick win this is because if the search warrant is good, then you don't have to. There's nothing else to even prove, right? There was coke in his house. They tested it. It was coke in his house. There were guns in the house, and there were kids in the house. It's almost like there's no contest here. So without that coke being thrown out, without that search warrant being thrown out, Nick is essentially screwed. What do you think, Kurt?
Yeah, I mean, I agree, because if the search is valid, then they looked in the places they were allowed to look. They found the substances. Presumably, they tested positive by the lab, and you're going to get confirmation of that. So as long as you're in the house, and of course they found the gun, which under both state and federal law you're not allowed to have. If you are a user of drugs, you're not allowed to have firearms. Plus, kids were in the house in which drugs were present, which was the child neglect charge. That kids are present in a place where the kids are, so we know there are kids there. So as long as the search is valid, you're toast. Yes. And you're looking for a plea or diversionary deal.
Yes.
At that point.
Yes. And I think that's where Nick is going to go if he loses this motion. But first, now since you guys have a little background on it, let me show you exactly what I'm talking about in terms of this is the little document I put together so we can just understand where we're at with this. So I'm adding it to the screen. All right. So first, Nick is asking for what's known as a Franks hearing. And he's saying that there were material misrepresentation and omissions in the affidavit in support of the search warrant. So we'll talk about that's attacking the search warrant, as we were talking about before. Throw out the search warrant. Nick is also asking that, hey, even if the search warrant is good or not, regardless of the search warrant, you shouldn't have seized the firearms because the seizing of firearms was unlawful because they had nothing to do with the drugs. So those are the two things Nick is asking for in this motion practice. Is that a fair representation of that?
That's it. That's the two things.
This effing sucks, no matter how anyone looks at it. But if there's anyone that's happy about the situation has something wrong with them. Yes,
Yeah, I mean, there are a lot of people who are very gleeful at this, which seems a bit inappropriate, but
yeah. Oh, but for I know I was looking at meme copium. I think some people have like have had an issue with Nick over years and years. Not meme copium. I don't think so. But I think there's been some people who have axes to grind, and now it's just kind of the downfall of Nick. They're going to jump on their high horse and grind that axe. But again, I think this is for us. It's all about the legal analysis, and that's what it's for, and the fascinating parts of it. And again, if I thought Nick's arguments were good, or if I thought the states, I'm going to tell you, and to everything else be damned. So the rule of law that we're talking about is a Franks hearing, and that's under Franks v. Delaware. And for a defendant to get a Franks hearing to challenge the sufficiency of warrant, he's got to have an affidavit supporting the search warrant contains a false state. He has to have an affidavit supporting that the search warrant contains false statements, a false statement that was made knowingly, intentionally, or with reckless disregard for the truth. And the false statement must be necessary to the finding of probable cause. So that's what he's asking for the Franks. He's saying the cop lied on in his affidavit intentionally, and that without that false statement, there would not be probable cause. Does that make sense?
Yep.
Simple?
Yep, the cop has to lie.
Yes, and you have
So
to
the cop,
be able to show they lied.
the cop does have to disclose anything that would tend to indicate that this is not the suspect that he knows about, but he only has to indicate what he knows about. So he has to be honest. He can't obviously make up facts that make the person look more guilty. So he can't make up bad facts, and he must disclose any facts that he knows of that are good for the defendant. And that's the standard, basically. And it has to matter.
And it has to matter. And it has to matter. That's I think one of the more interesting part. Remember, for 26 months in, I'm not sure if these are your people or my people, but I'm bringing them up.
Oh no, it's combined stream, man. We'll bring them all together. Happiness for everybody.
All right, so we've just gone over the plain. So now we got the plain view doctrine. Now it's been updated a little bit because this last one about inadvertency, it's really not. It's less likely an issue, but
it's no longer dispositive.
Yes.
That last element, that it's inadvertent. So in Franks, they listed these 3 elements, any one of which would be enough to win. But in a subsequent case, the United States Supreme Court said that last element is not dispositive. So it can be purposeful and still satisfy Franks now. So
the plain view doctrine is essentially the officer is lawfully present at the location. So in this case, in the case we're talking about now, the officer would have been lawfully present in Nick's house. Now, a search warrant makes it lawful for you to be in Nick's house. So you have that element will be satisfied. The second element for the plain view is that incriminating nature of the item is immediately apparent. So if you go in that house and you find cocaine, then you find drugs. If you find cocaine, which is drugs, and then you see a gun, the gun now is immediately apparently unlawful because you have cocaine. Now let's we did this in reverse. We found the guns, but found no cocaine. Then I can't seize the guns,
right?
Because they're not apparently. There's
nothing illegal about having guns in and of themselves. So without more, if you just find guns without more, that's not evidence of a crime.
So in this particular case, as soon as they found the cocaine, that automatically made the guns illegal, available for it to be seized. So that's what it is. So now we're going to look at Nick's arguments. He's arguing that deputy, he calls him deputy and detective, Poplin's affidavit contains material misrepresentation, specifically that they claim that the video used as evidence was altered, not the original defendant's video, and it was unreliable. Defendant also asserts Poplin failed to disclose the video modifications issuing the warrant, which could have affected the judge's decision in issuing the warrant. So he's saying there are 2 videos. One is the original, and it has all the stuff in it, and there's another one that was altered. And the altered video is the one that he showed the judge versus the original video. And Nick is essentially saying here, which I think he has to say, is that if you use the unaltered video, there would be no probable cause, right? You'd have to that has to be the conclusion here, right, Kurt?
I don't know if it necessarily has to be the conclusion, but it certainly makes logical sense. It's like what you viewed certainly isn't sufficient. So there's that.
Well, if what you've so what I mean by that is that if both videos are identical, that you lose the argument, right? You essentially lose the argument. If the original video and the copy they're talking about are identical, then I think you lose the argument because you still rise to the probable cause, but they're the same video. But if they're different, then I think you have a different argument.
Sure. Yeah, definitely different.
The Fifth Circuit seems on the path of destroying 922 G3. Sure, someone presently intoxicated may be able to be disarmed, so that may even change. I'm not sure what we're talking about, but
We're talking about the federal law that prohibits a habitual user from being in possession of a firearm. That's 922 G3.
but
In the Fifth Circuit, there have been, of course, some judges who have suggested that 922 G3 might be unconstitutional, but I don't think the Supreme Court is really prepared to go there at this time. So I don't have strong hope for the Fifth Circuit, and even if I did, I don't think it's going to apply in this situation. But that's a constitutional argument for another day. And the only way that works for Nick is if he keeps his case live long enough for it to matter to him. So if he pleads out, then that's the end of his case. So
yeah,
I don't think it's gonna impact him.
So, but I think even with this, and
Maybe
plus
someday.
he's not in the Fifth Circuit either. But I would also say this. But right now, Nick's first argument for the Franks hearing is that about the video. The video's been altered. Essentially, the video's been altered, and without that, the altered video, there wouldn't be probable cause. And the defendant further contends that law enforcement relied on a rejected child maltreatment report and should not have been a part of the warrant application, which we talked about earlier, which we talked about on the last time we talked about this, where there was there was complaints of child maltreatment, but the people at the place, the child services person didn't believe it warranted child neglect or reported child neglect. And you made the distinction that there were two separate pieces of law for that. Like, this is the penal law, where that's one thing for child endangerment versus child neglect under the Health and Human Services law, which deals with children, right?
Right. Yeah, correct.
So there are different standards. One standard may be like generally criminal law is higher, but in certain places, like in civil, the civil standard is lower for positive evidence versus beyond a reasonable doubt. So I don't know what the child safety standards are, but obviously they're not the same. So Nick is saying,
well, ultimately for removal, it's clear and convincing.
Yeah, all right. Which is lower than beyond a reasonable doubt. Think of it's lower than a reasonable doubt. So now for the firearm seizure, Nick is saying that there had to be this connection between the drugs. There's a substantial connection between the crime being investigated, which in this case was drug related, and the guns. But now this is like one of the first times I think I've ever seen somebody make an argument that you go into a house with cocaine and guns, and that the guns are unrelated to cocaine, right? It's just like,
I'm sure it's not the first time. I'm sure there have been more. I imagine that when it comes to drugs, every possible combination of arguments has been made somewhere, sometime. There's not much new under the sun left at this point. I'm sure someone has tried the guns are unrelated to the drugs argument. I'm imagining it's not been successful.
Just imagine somebody goes into Scarface's house and they say hello to my little friend. None of these guns are related to the cocaine.
Just speculating. It is not the first time that we found guns in the possession of someone who uses drugs. And imagining this issue has been adjudicated before. So
yes. Oh, and just so everybody understands, and the description, Kurt's actually got myself, Kurt, and actually a whole bunch of different law firms in the country are working on this case against Google, where they have essentially lied to people about using incognito mode. So some of the people were asking me about that. It's in the description of my video. I think Kurt's getting his link this week. And we're working with a California law firm, actually, with a whole bunch of law firms to help expedite this and help people, just help hold Google accountable for essentially just lying to everyone and saying, hey, really keep your data, but then really keep your data. So
Yep.
So if
So
anybody's
yeah, as Nate says, Nate and I are working together on that, and hopefully I'll have my own link up on that issue pretty soon. But yeah, Google really messed around on this issue. Class action status was denied, so Nate and I and a whole bunch of other lawyers are working on this issue, and Google has some real exposure here because California has some statutory penalties per violation.
yeah.
So that $5,000 per violation can really add up pretty fast. So Google might have to write one hell of a check one day. So yeah,
But
should
like,
be exciting.
well, like I said, Kurt's gonna have his link soon. I got my link in the description, and if you'd like to, just check it out, sign up, read all the documents. You'll see we're involved. You'll see our names up there, and and if you can watch my last video on the topic. But let's get back to the Rekieta stuff. All right, so now the state says the Frank's hearing, he doesn't meet the high standard. He argues there's no evidence that Detective Poppin made any false statements knowingly, recklessly, or any disregard for the truth. The state contends that the video was authentic, came from the defendant's YouTube channel. Additionally, the state points out that the defendant provided no sworn affidavit and no proof of support of the
Yeah,
claims of
that last part is a
misrepresentation.
real problem. That he didn't provide any affidavit or other sworn statements to say that what the cop said was true. He's just making vague allegations. So that's a real problem for a Frank's motion.
Yes. And based on the arguments presented, so this is the conclusion. I'm saying the Frank's hearing is going to be denied, and I'm also saying the firearms are still going to be good. I'm saying the Frank's thing is going to be denied because even though the arguments are compelling, there's no real affidavit here, and he's got to provide something more substantial than just that they did this intentionally. And right now, I just don't see it. And I think the firearms it's plain view all day, every day. So those are my predictions.
Yeah,
But now,
unless there's some specific fact which has not been brought to our attention. So, if the guns had been covered with a T-shirt and they had to remove the T-shirt, then then it's not plain view. But since that argument has not been made, I'm assuming that's not the case.
yeah, or even like I know they were sharing that and they may have been under a bed or something like that. But if I'm
Yeah,
searching, people forget plain view is if I'm searching for drugs and I search under your bed for the drugs and I see guns under the bed, well, I'm lawfully allowed to be under this searching,
yeah.
So
This is a
even
good
if they're
point.
just even if they're not open on the table, I can still, if they're in the search area or a reasonable search area. Again, I can't search for an elephant in a suitcase. I'm looking for an elephant. I look in a suitcase. Then that's obviously not plain view because what I'm looking at suitcase for. But
You're not
if I'm
going to
looking
find
under
the
the
elephant
bed,
in the
that's different.
suitcase. You're just going to find someone's boyfriend.
Oh yeah. Sorry. Suitcases are getting it's getting too easy to pack things in suitcases nowadays. But here we go. Judicial 8th district 9/6/2024. So this is Nick's defendant's memorandum of law in response to state's memorandum of law. So the state responded. We saw both sides of the argument. Now Nick is responding for the last time because he's the defendant, so he gets the last word. State speaks first, defendant speaks last in this case. So in this particular
Yep.
instance. So go ahead.
No, you're right. Whoever has the burden of they can respond to the issue. So because it's Nick's motion, he has the burden of making this motion, so he gets to respond last.
All right, here it is. The state has reasonably restated the two issues remaining before the court with regards to the defendant's pending motion. The state's conclusion, however, is incorrect. The defendant has made a showing sufficient to warrant. Am I reading that right?
Yeah,
Yeah, I'm reading that right.
there's a typo. That's
Because
fine. We'll move on.
I'm like, oh my god, I'm reading it and now I can't read it. And what's going on? All right, so defendant has made a
Mayday. Yeah.
showing sufficient to warrant a Frank's hearing, and the defendant has shown that the seizure of firearms was unlawful. Okay, so those are just two conclusions. He said, okay, that's his introduction. The formatting looks a little better too. The United States Constitution and the Minnesota Constitution guarantees defendants the right free of. So this is just the law, free of unreasonable search and seizures. The court stands bulwark against the. Okay. So we know all this. Is showing sufficient to invoke Frank's hearing. So this is where we get into the meat and potatoes. Reading the law as suggested by the state would lead to a patently absurd result. What's this
Ooh.
called? All right, so all you law people out there, it's called the slippery slope argument, right? Am I here with you, Kurt?
Yeah.
Oh, yeah. He opens it up. We're going to talk about the slippery slope. The state's tortured. I like the alliteration here. Construction of the prevailing law would ensure that no defendant could ever succeed in challenging an affidavit. That's a bold statement, brother.
It's not all that. No.
I must have didn't read the state's motion well, because this guy is
Wow.
laying
Yeah.
it out like this is bold, right?
No, it's not that you can't ever challenge it. It's just that you actually have to have evidence and facts and be able to
Kurt,
show that the cop actually lied, with saying, this is true, and be swearing to certain things to say that the cop is lying.
Kurt,
The cop has made a sworn declaration. It's the affidavit for the warrant.
Kurt,
So the cop has made a statement under oath. So where's the statement contra to say certain things aren't true?
you're bringing us down, Kurt. You're bringing us down. Come on, Kurt. You're bringing us down, bro.
Just saying.
All right. The notion by itself offends both the warrant clause and the due process clause of the United States and Minnesota's Constitution. Now, I will say this. The wording in this first paragraph, it's just this is essentially all nonsense. Like, the judge has to read, these are all conclusions about, how crazy this particular stuff is. But now you're going to lose if what you have in the rest of these paragraphs aren't compelling stuff. You're going to lose a lot of credibility with who's ever reading.
Yeah, you got to be careful when you come out with that much fire out of the gate. If you can't back it up, man, you're going to make the judge's eyes roll, and you'll lose whatever you had. You got to be careful that you can back up what you're trying to sell.
Yeah, this guy's saying this offends the Constitution. This is that bad of stuff. But again, you also need that it needs to be that high level for the Franks hearing. So I understand, narrating it in this way. As is obvious from the substance of defendant's motion to suppress and dismiss, defendant is challenging the accuracy of material facts and the facially valid search warrant. Therefore, the district court is not confined to the four corners of the search, and the court may look to extrinsic evidence. Well, it
would help if you had extrinsic evidence. That's part of the problem. Is that you didn't provide a sworn affidavit to say, you're just saying things.
Despite being nearly 5 decades old, this is the case, remains good law, and no subsequent decision of the Minnesota Supreme or the U.S. Supreme Court has degraded its authority. The rules articulated for the Minnesota Supreme are simple and finite and include, the defendant has a right to challenge the truth and accuracy of affidavit. You can. Such challenge should be made in omnibus hearing. The trial court determine if the defendant proceed sufficient evidence.
Sufficient evidence. And
element
number 4 again is a problem.
And the affidavit, a defendant is entitled to some form of disclosure provided herein, makes sufficient showing that such evidence is necessary to support the charge, blah, 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 and the trial court may rule on the validity of the search warrant. Okay, all right. So he's put the rules there, evidence, search warrant. Clearly, the court can go outside the four corners of the warrant in its analysis to sufficiency of challenge of the warrant under Franks. But that's all right. So something's off here, because of course the court can go outside the four corners of the document, but you have to provide the evidence in a form of that sworn affidavit. That sworn affidavit is outside the four corners
They're
of the
about to
document,
tell me
right?
I'm wrong, so that's fine.
Clearly the court can go, all right, so the state citation to U.S. v. Matheson is misleading. Matheson applies federal common law to federal criminal matter. Minnesota has never held that only one way to make a necessary showing for Franks hearing is to produce an affidavit. There it is. Indeed, neither did Matheson itself. In that case, the Eighth Circuit held that without an offer of proof in the form of a sworn affidavit or witness or some other reliable corroboration is insufficient to make the difficult preliminary showing.
Yeah, so I mean, okay, fine. So you want an offer of proof, which is a legal concept. It's also called a proffer. It's basically you as the attorney saying that certain things are going to be true or going to be shown. Now you can do that obviously through a witness or an affidavit, or something else that corroborates the statement. And the question here is, well, what do you have that corroborates it? So it's like, okay, I didn't produce a sworn affidavit. I don't need to. It's like, okay, fine. You don't need to produce a sworn affidavit. What did you provide in the form of corroboration of what you were saying, other than just you saying things? It's like you say, well, the cop got it from this. What's your corroboration? It's not clear that there is. So I'm not even sure that even under this looser standard that Nick is meeting that, to be honest.
Well, we will. Right now, we're about to see. So the defendant's YouTube video. Okay, so let's look at this. The defendant's YouTube video. Even if Matheson is applied, in this case, the required. Now, this is nice. Even if Matheson applied, I like that because it still says okay. Even if we use their standard, which is not the standard, it still doesn't work. The required corroboration is information readily discernible to the court, namely the altered video. I'll agree with this. Because why do I need an affidavit if I have clearly evidence that you're telling me this is the video and I'm telling you this is not the video? This is why it's wrong.
If it's readily apparent from its face, then fine.
So Nick, this argument, I would agree with Nick and his counsel. Ironically, it is the state it is the state that has provided the court with the evidence necessary to corroborate the defendant's assertion that Deputy Poplin, he's deputy now, huh? He was a detective. As deputy, materially misled Judge Fisher, especially as to the origins of Deputy Poplin's review, the video Deputy Poplin reviews. So I think this is actually not a bad argument. In other words, why do we need an affidavit when the evidence is produced through the affidavit of the officer, right? Here's the affidavit, and here's video 1, video 2. It's apparent that they're different. What do you think?
I mean, it can work if it's readily apparent on its face, but that doesn't seem to be what the state is saying. The state seems to be saying it reviewed the entire thing and provide the entire thing. So,
and I would ask you too, in this particular case, let's say, would it be sufficient to get, let's say, an expert or a video expert, or even have Nick himself say, okay, this video is different, blah, blah, blah. Here's my sworn affidavit attesting that why these videos are different.
That could work.
Yeah, because it's saying an affidavit, but it's just an affidavit of somebody who knows what they're talking about, right? I've reviewed both the evidence. Obviously, like I'm surprised they just don't put that in. That just seems like it'd be simple enough to do. Right? You get some tech. Here, this guy's been looking at videos for 20 years. You pay him $1,000, and there it is. Okay, yeah, here's the affidavit. You may have to call him as a witness, though. But only you need is the affidavit. The following is submitted in response to the state's assertion that defendant's exhibits are incomplete and create a misleading picture of the evidence provided. So this is going to be the fight right here. This are incomplete and create a misleading picture of the evidence provided. On August 30th, the state uploaded an exhibit that purports to be video of the Deputy Poplin watched prior to the warrant application. Okay, so this is the video. So he said this is the same video that the state produced in initial disclosure, which was referenced in Supplementary Report 8, blah, blah, blah. So they say on August 30th, they uploaded this digital evidence with blah, blah, blah. So all right. Detective Poplin, however, has 2 problems with Supplemental 8 in his affidavit to support that. Firstly, in his initial supplemental report, Deputy Poplin identifies his digital evidence as including, okay, so let's see what this says. PowerPoint video clip of Nick Rekieta's online podcast, which shows white powder substance, blah, 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 blah. Okay, so that's what he showed first. Both the PowerPoint video and the screenshot referred were provided in the state's initial disclosure. This is a screenshot taken from the PowerPoint video. So now we get to see a screenshot. Okay, so here's the PowerPoint. And what channel is this? This is Nick Rekieta's stream methods and his appeal. Let me see if I can find it on YouTube. So that's the stream. Let me see. Yeah. I'm just trying to see if I can find that stream.
Is this YouTube Backwards Internet, May 21st, 2024? Is that the name of the channel? Yeah, it looks like, because it's a backwards B. I'm going to go with that.
Yeah.
Backwards Internet, May 21st, 2024.
Yeah. So let me look at, yes, YouTube Backwards Internet. All right. And that's Nick's Coke screen, right? Let's say Nick. I'm going to put Rekieta.
Nick Rekieta's drunk stream after losing his appeal.
Okay, now I'm gonna pull this up
And I
on
know
stream.
the video is 4 hours, 4 minutes, and 4 seconds, which is the right length of the video.
So let's look. So this guy has the video up. It's 4 hours, 4 minutes, and 4 seconds long,
which is the correct length.
which is the
That's right.
correct
That's
length.
the right length.
So they got Rekieta's stream from this guy's stream. All right.
Okay, fair enough.
Shout out to him. He gets shout out
Shout
on
out
all the
Packers
channels.
Internet.
Shout out to him. All right.
Can you play like a couple minutes of it, just to, like, scrub to somewhere in the middle? Just play just a second of it, just so
I
we
was
can
going to
see,
see if there's any timestamps and just mess
Okay,
the
fair enough. We'll do
timestamps.
it that way. That's fine.
So we'll mess the timestamps. Yeah. All right. So this is the clip embedded in the PowerPoint presentation does not come from the defendant's YouTube channel, as evident from the screenshot taken at the same point of Bob. So this is
it didn't come from his channel, but that doesn't mean it's not his video.
250-27, and he shows the lawyer it's peeing. So that's where we're going to. So I'm gonna go back to the video on YouTube, and we're gonna go to 250-27. I know it's hard to see. I can see it though. 250-27.
It looks like, just from scrubbing it, it looks like next video to me.
250-27. 250-27.
I mean,
so this is it. Yeah, this is it.
Yep.
And Nick's original video is 4 hours, 4 minutes, and 2 seconds.
4 seconds.
So, 4 seconds long. So this is the full video.
It looks intact to me.
Now you know what? It's funny. I see why they're using this because like you don't want to use any every other clip of Nick. He looks like so strung out.
Yeah.
So they're like, let's just use this because it doesn't look so strung out.
This video, just from the scrubbing we're doing, looks essentially unaltered. It looks intact.
All right.
And then I think at one point Nick says, "Oh, it had a watermark on it because it had his logo on it." I'm like, okay, yeah, sure. The watermark is definitely what's making this video change in a substantive way. Yeah, give me a break.
Just imagine, like, this is.
It looks right to me.
Yeah, Nick is talking about losing his tail. Yeah, it's like you don't want the judge to see any of this. It's like kind of like, oh, he's not on cocaine. He's not on cocaine. Yeah. All right. So, that's what this is saying. This is saying this is not, even though now this is the full 4 hour 40 video they sent it to him. 2 videos are clearly different. Okay, so now they're gonna force me to freaking go to Odyssey.
You've got to be kidding me. The 2 videos are clearly different, with another creator putting his or her stamp on the video, upon which the deputy and by the extension the judge relied. What a weak ass argument.
Hold on. Let me go to Odyssey.
Here with that weak stuff, man. Come on.
Let me go to Odyssey.
Come on.
Excuse me. Let me go to Rekieta. Hold on. Let's do our due diligence, brother. Yeah.
It's got a watermark on it. It's totes different, don't you know?
All right. So we're on Rekieta's channel. We're looking at his content. This was we gotta go to content. And we're looking for the Coke stream. When was the Coke stream again? Oh, matter of fact, I'll show you this. I see you on here. Look at you on there.
Is that the Denny's clip? We could watch that again and see if it gets funnier.
Oh, I don't know. This is a whole 4 hour. This is a whole stream. I'm looking for the 4 hour stream. Is there?
It was on there. Yeah.
Maybe he might have took it down. When did he do the Coke stream? The Coke stream was how many months ago? It was
up there until recently. So unless he removed it recently.
No. But I'm saying I had to look for it. It's farther down, right? We're talking about how many months ago?
May 21st, I think, something like that frame.
All right, so looking at man. See what Odyssey, because it was just up here. 1 hour. Oh, let me see appeal, because you know what? Let me Control F. There it is. Oh, look at it. It's right here.
Yep, there it is, right there. Yep. 4 hours, 4 minutes, 4 seconds. It's the exact same length.
All right, so this is,
which is kind of amazing, actually.
So let's look at that timestamp at 2050-27, 2050-27. Just because we're thorough.
But the watermark, though, Nate. But the watermark.
timestamps on. Yo, the timestamps are identical. So what's he arguing here? What the hell is this?
The backwards internet guy had a watermark on his video, so it's totally different. It's not the original because there's a watermark.
Because of what this guy, because he has a watermark. Oh my god, this argument's so bad. I think they just have to watch the video. Look, the video is exactly the same.
It looks correct to me. Yep,
it's the same video. All right,
yep.
So 4 hours and 4 minutes, full content, the same exact thing. All right,
it's going great.
So let's go back. All right. So I'm kind of surprised at this argument. I'm surprised at it. I was trying to get the benefit of the doubt, but I'm surprised at it. I'm going to leave this up and close this one. Stop this in the background, so I stop listening to it. All right. So, so let's read this again. The videos are clearly different, with another creator putting his or her stamp on it. Video, which Deputy Poplin, by extension Judge Fisher, relied. The primary basis for the public declaration that defendant was actively using cocaine with the white powdery substance on defendant Poplin had a duty to inform Judge Fisher that he just watched the video from another creator's imprint overlaid.
That would be the watermark that we're referring to. Get wrecked.
And not the defendant's actual video.
It had the imprint. It had his imprimatur, his seal.
He almost makes it seem like the coke was the thing that was imprinted on his nose.
Lord.
This argument's pretty bad, bro. This argument's pretty bad. It's just pretty disgusting.
Someone asked if it was a framed sheet of Yu-Gi-Oh cards in the background. No, they're Scottish tartans.
Clearly, the video was reenacted with Nick Rick is in his body double. Oh my god, this is crazy. This is pretty insane. So all right. So we've now established the judge is going to look at. All right. So let me see the original. Let me see the copy. If they're both identical, Nick is screwed, right? How could you not?
No, they're the same video. They're frame for frame the same, except maybe it has that little watermark on it when you play it because it has the little creator's thing on there.
But he's trying to make it seem like the watermark is the cocaine on his nose. I don't think so. I don't think so.
Yeah, no.
Especially as the existence of the alleged substance, especially as the existence of any alleged substance is questionable. Deputy Poplin's failure to do so, leaving Judge Fisher with the impression that he had watched defendant's unaltered video, is a misrepresentation.
If this qualifies as a material misrepresentation, I don't know what to tell you, man. No.
The state, however, has a second problem. The metadata.
It's not some sort of hugely edited thing with crop ins and effects and edits and jump cuts. It's fine.
The state, however, had a second problem. The metadata on the video's initial disclosure, which shows the state hadn't downloaded defendant's original video, and the video they did download was after the warrant was requested and issued, is not defendant's original video. Oh, the metadata. Oh no. Oh my god.
Wow. The metadata. Well, I mean, yes, the metadata would be different because it was uploaded to a different channel, which means it's going to have a different time and a different date, a different creations time. Yes, that's true. It is going to be different because it was a re-upload. Wow, you've caught us. Amazing.
All right. I'm not going to say they're dummies, but this is pretty dumb. I'm going to show you something. So when was this motion filed? This motion was filed September 6th. So right now, September 9th. So I'm going to go to properties of the thing that I just downloaded because I want to show you something. Get info. Because this is what we're talking about.
I'm sorry, but if you give this to what's her name, Pam from the office, and you ask her to determine what the difference between the two videos are, these are the same video, man.
Oh, yeah, no, definitely. But the metadata, so you see it when it says created, modified, and accessed. So this is on a Windows computer anyway, so I'm on Mac. But anyway, if you were to, whenever you make a copy of something, it automatically is going to be created, modified, and assessed on that day.
Yeah.
So like all the documents I downloaded from the state doesn't have created on the 6th. It has created today because it was created on my system today. So all of them would actually be the same. So he doesn't know, like, this is not the metadata of when it was actually created. This is the metadata of the file name on the system. So none of this, and like you're saying,
I concede the point, Nick, that this video is not from your channel.
No,
I concede it's not from your channel. I do not concede it's not your video, though. That is no.
But he's also saying that it was after the search warrant had been
requested. That's how a
requested.
re-upload works, and that's how
But
time
that's
works.
how the re-upload works, because
it would necessarily be after. If it was before, that would be amazing.
Yeah,
you know, because it was re-uploaded before it was created. Wow, we've invented time travel.
No. All right. So what Nick's argument is that they never watched the full video, and they just only after the warrant was issued, then they went and downloaded the full video after the warrant was issued, and they lied to the judge by saying they had the full video. But what my response to that is, they don't know what they're talking about, because this doesn't prove that, because these numbers, whenever I download the video, all those numbers are going to be the same from the day I downloaded. So he could have had the video before, but when he was making a copy of it, the copy would say they created, like, it would say after. You understand what I'm saying? It would say after the warrant was issued.
Okay. Well, I mean, that might be the time that they saved it to their system for the purposes of disclosing it. So it's quite possible that they didn't download it to their system when they initially viewed it, and then as part of their disclosures to the parson, they then downloaded a copy of what they viewed originally and then shared that. But
the simplest explanation for here is that they downloaded it, and then when they were doing discovery, they made a copy of the file.
That too.
And the copy of the file
they did have a copy on their system, and when they made the copy to whatever device they handed it to, that changed the date for the copy. That too. That also makes sense.
That's what this is showing me. That's what this is showing me.
That makes sense.
And the lawyer is saying no, but that's what the lawyer doesn't understand. Pinch and zoom. Okay, sorry, people. Yes, I will pinch and zoom so you guys can see it. Here you go. So this is when the MP4 was copied. Archived from 5/20/2024, MP4, and this is when it was copied and sent to Nick's team in discovery. So that's why all these are saying Friday, because that's when they sent the disclosures, as they just said. So I don't think they understand how that works, but it's all right. So we know the videos are the same. And now, even if the state opines the other brand on the clip may have been from the application used to make the clip, Deputy Poplin had a duty to inform the judge that he was basing his affidavit on an altered video. I think they're trying to say any alteration of the video, any alteration. Let's say if the video is 4 hours and 4 seconds long and it was 4 hours and 3 seconds long, that 1 second off the front or the back is enough to throw out the warrant.
No, I don't think so.
So
no, because even if it had been partial, as if the cop relied on it, and it's not, the cop didn't have a reason to believe it was materially altered or made a material difference, then I don't see it. It's a very, 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 very weak argument, in my opinion.
Yes. But this doesn't prove that that's when the video was downloaded or created. This proves when a copy was made and sent. So that's unfortunately that's what they can't. He doesn't understand. All right, even if the state so now I think the whole video thing is nonsense. I don't know why the state would grant a hearing. I mean, the judge would grant a hearing unless he's just being overly cautious. Because if I'm the state, let's just look at the two videos. Here's video A, here's video B. Here's Nick's video, here's Nick's original video. Here's the other video. Is there anything in there that's different other than the stamp on the bottom right-hand corner?
No.
So
there's nothing other than the stamp that's different.
And there's nothing materially different either. So
Yeah.
yeah, I think it's all garbage. The determination that Candioi County County Health and Human Services is relevant to and determinative. So now he's going to the second issue. The second issue is that let me just read it. Once again, the state, while correctly stating the rule, has reached the wrong conclusion. The screening of child maltreatment reports is controlled by an entity different from the set of statutes and standards than criminal offenses. The standards are much lower for screening child maltreatment reports. The state suggesting that failure to meet probable cause to satisfy the lower burden of proof for clear and convincing evidence standard. Well, clear and convincing evidence I thought was higher than probable cause. Clear and convincing is higher than probable cause. The state suggests the failure to meet probable cause to satisfy the lower burden of proof for clear and convincing standard has no impact on probable cause to satisfy a beyond reasonable doubt standard. I don't know. I was always under the impression, maybe I'm wrong.
No, that doesn't sound right at all.
Let me look this
The
up.
standards are screening are still probable cause to the best of my understanding. Now, ultimately, in the end, for removal, you only have to get to clear and convincing as opposed to beyond a reasonable doubt. And also, the state's inability to show maltreatment at a certain stage isn't that dispositive, I think, because the cops were searching for drugs. And so the question is, what is the probable cause of drugs in the house? So the children being abused or not, is at best only evidence of the thing, not the thing they're searching for. If the warrant was for searching of evidence of child abuse or child neglect, then I would agree much more, but it's not. So it's more of a peripheral issue. So even if it's problematic, it doesn't seem like, I don't think that's right.
Yeah, and I don't know. I understand what they're going for, but it's not an end all be all. There doesn't have to be. They don't have to say, yeah, there's evidence of child neglect to say it, or it doesn't have to, because again, the warrant was for drugs, not even for child neglect. And the only reason why Nick is being charged with the child endangerment piece was because he had drugs and guns in the house with the kids. So it's ancillary to them finding the drugs. If they didn't find the drugs, he wouldn't have the child welfare charges. So even in this, let's say they say, even though they said there was no child endangerment, well then okay, that doesn't mean there's not drugs in the house. You know what I mean?
Right, exactly so.
Because the
That's
warrants for
what I was
drugs.
saying in so many words, yeah.
Yeah. So all right. So the requisite showing necessary to initiate a child protection matter being much lower than that necessary to clear a warrant should have foreclosed that basis for Deputy Pop, should have foreclosed that basis. And even if it didn't, well, yeah, he can still then. He had a duty to tell the judge that the documentation had already been made that the allegations found had been found to be insufficient, which I think they have a beef. I think they do have. I think they have a legitimate beef here. Because if you're going to say that there was a report, if you're going to tell the judge there was any report for child services, then I think you should tell the judge it wasn't. The allegations were found to be insufficient.
I see that point. Yeah, I understand that point.
So I'm going to give Nick's team credit here. I do think they have a legitimate issue here. His omission was misleading and material, as was his failure to inform Judge Fisher that blah 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 had determined that the incident or condition does not fit. I'm telling you, bro, they're wrong here. Probable cause is lower than clear and convincing evidence, because clear and
Much
convincing
lower.
evidence. Yeah, so
Clear and convincing evidence is more than you need in a typical civil trial. It's more than preponderance.
yeah,
It's
so
somewhere between preponderance and beyond a reasonable doubt. On a percentage scale, it's something on the order of like 70%, give or take.
Yeah, so why is he saying? Because he's saying here that that's what's got me still tripped up on this, is that he's saying the state suggesting the failure to meet the probable cause to satisfy the lower burden of proof for the clear and convincing evidence standard has no impact on probable cause. So here they are saying that clear and convincing is a lower standard than probable cause.
Yeah. Yeah, it's a little bit weirdly phrased.
I don't know. Yeah, it's not making any sense. I believe the CPS letter screening out the child case was issued on the day Detective P started his investigation, meaning the additional allegations and the coke stream came after. Yeah, but again, yeah, I think that's right, and I also think too that even if we do screen out, is leaving this out, is this material to the warrant? Like, so let's say if you say, okay, we're going to take out the child services report, you can't use that to evaluate whether you got probable cause. Does that affect whether the judge is going to issue that warrant with the totality of the circumstances?
No, I don't think so. No,
Yeah,
I
so
don't think so.
I think you can. So his omission was misleading and material, as was his failure to inform Judge Fisher. Blah, 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 had determined that the incident. So I'll slap the cop on the wrist for that, but I don't know if that gets me to a Frank's hearing, because even if it's true, remember Frank's hearing, it has that even if it's true, can it change the outcome?
Right.
And I believe even if this is true, it doesn't change anything. So I think you lose on the video, and I think you lose on this one, because this one doesn't matter.
This is by far and away the best argument that he's got.
No doubt about it.
That the cop should have disclosed that the CPS had said that they did not find probable cause. Now, assuming the cop was aware of that at the time, and then the argument would be that he should have included that, even if he included other things that would have gone the other way, because the cops might have developed evidence beyond that point, but he should have still included it, which is typically correct in law. You should indicate anything that you're aware of that in case the person didn't do it, even if other evidence suggests that he did. So you give the judge the full picture. So this is by far and away the best argument, is that the cop should have mentioned that CPS found that they weren't able to meet probable cause. But to my mind, it is still tangential of an issue to the ultimate issue of trying to find evidence relating to drugs. Because the issue of probable cause is, do we have sufficient basis to believe that we can find drugs in the house, the place that we're going to search, right? Can we find the thing we want in the place we want to search?
Yes.
Are there drugs in the house? So the evidence relating to the children are, to my mind, still tangential. The primary issue you're concerned about is what evidence is there of the drugs, in which case the video is probably the primary piece of evidence, which is then supplemented by other things to show what it depicts. So I think it is too tangential to my mind, but it is that by far and away their best argument.
It is their best argument. I think, and right now, if we talk about what they have for probable cause, they have the church pastor, they have the school teacher, they have the other people from the church, they have members of their family, right? All those people are saying they look strung out, they look like they're on drugs. You got Aaron on stream saying, I was in the Rekieta house and we were drugged out and coked out of our minds. The first time I've done this was at the Rekieta's house. Now he said that he didn't go to police with that. He was saying that on stream. Police watched that stream. Oh yeah, this guy's a cokehead.
Cops watch streams too, man. Social media has been the cops' best friend. I'll tell you what, man. Cops love the social media. It's great.
Oh my God. Yeah, he's got all this coke in his house. This sounds great. Let's go look at his video. And now he's going off stream with coke on his nose, looking all strung out. So I'm assuming they have a lot more for probable cause. So if you take out, the child services report, I still think you have enough for a warrant. I think you still have enough for a warrant. Because and especially, and I'll say this, if the warrant is, if they have to go to a hearing to fight the warrant, then you may have to bring in Aaron, because Aaron, I think, also gives you more for the warrant. He's not an end all be all, because the warrant's about totality of circumstances. But I think Aaron does give you some perspective. Yeah, he was on those streams saying that he was coked out of his mind in there with Nick. And don't forget, they were previously friends, and then they weren't friends anymore. So you mentioned that, but I think if you're talking about for the search warrant, you can use Aaron, who's going to be a lot more helpful. But I think for the trial, I think Aaron, I don't know if I'd even call him as a witness. There's really no need to.
No, he's a nice to have. He's a nice to have. But he comes with a lot of baggage. So at this point, probably not. I probably don't come to the stand.
So this is the end of their first argument on why they need a Franks hearing. So I think the Franks hearing essentially, and I don't mean to say this in a mean way, but I think the video is borderline ethical. Like it's as borderline ethically an argument I think you can possibly make.
You think that it's close to being unethical, in other words?
I think it's very, very close to being like essentially frivolous. And the reason why I'm saying that is because they're trying to use a lot of double talk within that first paragraph. The video is altered and there's this and there's this and there's coke and there's this and there's this. But we've just saw the video and we just saw both videos. The video is identical in every way except for a watermark. That's essentially what this all says. Those videos are identical except for the watermark. And the watermark, because it has a watermark, it's so altered that you should throw out the search warrant. If you just bear down their argument, that is the argument. Right?
Yeah.
And it's trying to coach it in that it's altered, is this, is that, is this, is that, is this, is that. It's no. It's somebody put that thing in the chat. I just saw it. Materially identical. So I think when it comes to candor to the court, the first question is, well, are the videos identical in every way except for the timestamp? I mean, except for the stamp. And if he says yes, then that's it. And that's it.
Yep.
So the state so now we're talking about the plain view exception for the firearms. I always thought this was it, but we'll see. The state is overly reliant on the plain view exception, which defendant distinguished in his motion. The state, however, failed to address the strong relationship between the seized and described items, standard or nexus, between the items seized and criminal behavior, standard raised in the defendant's motion. As such, the court should consider any counter arguments waived and grant defendant's motion. What? That's it for that argument? Yeah. So that's his argument for the firearms.
Yeah, that's it.
That's it, because you didn't address the strong relationship. So
that's a little conclusory.
So just so everybody understands, the argument from Nick is that there had to be a connection between the drugs and the guns for them to be able to seize the guns. And since there was no connection, then seizing the guns was illegal in of itself. The state came back and said, well, there's a plain view exception. If we come into your house with a lawful warrant for, let's say, something like not drugs, and we see other things that are illegal, like a dead body in there, then we can seize the dead body, right? And arrest you for the dead body. We were not in there looking for a dead body.
Yeah, that's what I would think. Yeah.
But there's a dead body right here. Oh my God. And we're searching for this other thing, but we found a dead body. In Nick's case, they go in there, say, we're looking for cocaine. Cocaine is found. We also find drugs. Yeah, cocaine. And now we're finding drugs. So is there a nexus between the two? Well, no, in that case, there's not a nexus. But having guns and drugs are illegal. So the guns are apparently illegal. So I don't see how they get past the plain view exception here, because they were searching, they were lawfully there, and they were searching in a place that they were lawfully allowed to search, and guns were there. So, and it shows you this is literally one paragraph. And his thing is, just because you didn't say why my argument was BS means you should just accept my argument and grant it.
Yeah, that doesn't exactly have the huge power to persuade, I have to be honest. So, yeah.
Let me see. Detective Public sought a warrant based upon activities which had already been deemed lawful. Ooh. All right. Conclusion. It defies common sense to say that the court can make a practical common sense decision, whether given all the circumstances set forth in affidavit before him or her, including the veracity and basis of knowledge of persons supplying hearsay information. Probable cause. Yeah. So for those of you who don't know, you can use hearsay when it comes to pretrial stuff, warrants, even in the grand jury, but you can't use it during trial. So, yeah, probable cause exists to issue a warrant, yet cannot use the same test to look at the information the defendant supplies on the motion to suppress when the information itself comes from that. Oh, sorry, I'm gonna call you back. Comes from that which is disclosed by the state in discovery. The defendant clearly satisfied the showing necessary to warrant an evidentiary hearing pursuant to Franks. I don't think so. I don't think you get a Franks hearing.
I don't think so either.
And I think even if you did a Franks hearing, it's just a waste of time.
Yeah, I think so.
The defendant, pursuant to the state's suggestion, does wish to turn this into a general probable cause dismissal. We're therefore the state's suggestion that the additional briefing schedule be set by the court. So they want to get a general probable cause dismissal. No, but there's no probable cause for any of this due to the numerous inconsistencies of detective. He's detective now. Detective Poplin's probable cause affidavit. It is unlikely that Detective Poplin could have seen or detected what he states. His integrity as a police officer is in question at this point. Accordingly, the court should schedule an evidentiary hearing pursuant to Franks, blah, 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 blah. And that's the guy. So, well, your thoughts. What do you think about this motion?
Yeah, so I still think it's pretty garbage, to be honest. I think that the arguments are exceptionally weak. As I've said before, the problem here in a lot of places is that the standard for probable cause is so low that it doesn't take a lot to get there. And the success rate on these kinds of things is exceptionally low. So as I'm trying to assess the probabilities of this, I'm trying to assess it based on the overall sort of likelihood of these things being granted. And it just doesn't have the shock the conscience kind of quality that you typically see in a successful Franks hearing, where you really catch the cop in an out and out lie, out and out manufacture, out and out deception, where you really catch the cop in like flagrant, blatant misrepresentations in a way that really shocks the conscience of the court. It doesn't really have that character to it. So while I think there's some elements here that are, the elements dealing with the child and the child services thing not being mentioned is by far and away the best. But it, as I say before, it seems too tangential. So I don't think the Franks hearing is going to be granted. They're a low probability event anyway, and I don't really think this is doing very much. So I expect the judge to dismiss this request within the next 30 days. So that's what I expect.
I'm with you. I think, because I'm thinking about this one two ways. One, the judge could say, okay, let's do it. Let's do the Franks hearing, just to dot the T's and cross the I's and say, okay, we've done it just to make sure it's done, and then say this is all garbage. But based on, again, my understanding of what I'm seeing here, it should be obviously denied easily. The video, this whole they've made this argument in this document to make it seem like the two videos are materially different, but the only thing they really have is the fact that that there's a watermark on, that there's a mark on one is not a mark on the other, but everything else is the same. I think that if the judge realizes that, I think that video argument is so bad, that the videos, then that loses all credibility for all the rest of the
That's a real problem too as a lawyer, and I've commented this more on appellate issues than, but the same thing in trial too. You have to be careful when you're making arguments to not bring in arguments that are so weak that they just taint everything. And so I've said before, like on appeal, like if you have 10 issues that you could appeal on, it doesn't necessarily mean you bring all 10, because really weak arguments can drag everything down. And I think this is exactly the same problem. This argument on the video is such a weak argument because it's so whatever that it can really put the judge off. And so you want to be really careful with that. And you lead with that argument. If you led with the child services argument, brought that in as a secondary argument, maybe, but I think he has some problems there on the tactics. Not sure it's necessarily tactically wise.
I think they also think that the part about the this part here where they have the screenshots, I think they think that's an automatic win. Like they think this is a win. Oh look, and I think this was their coup de grace to this, that that he allegedly, the video was downloaded or created after, not
Yeah.
knowing that this is just a copy of the video. So I think they put a lot of stock into that, and I think that that's going to backfire on them. Objective. Oh, thanks for being. Kurt is just as objective and unbiased as I am. I think
Yeah,
I think
think
somebody's just joking with the Kurt. I
it's
think
just
that's just a joke.
the thing that I'm sort of trying to calculate in the back of my head is trying to reach these things is the standards we're playing with, and also how courts view those standards. And courts, as I'm sure you can appreciate, don't necessarily like dismissing. They don't like saying that their warrant was invalid or that they granted it falsely. They don't like looking like the fool either. So they want to save face because they're human beings too. So in trying to assess this, you're trying to assess it based on those baseline probabilities, and you're like, well, it just doesn't have the character that you need to. So that's my assessment.
Yeah, but my assessment is, to be honest with you, the exact same as yours. You know, I don't see, and it's always me laugh to see. Barnes was like First Amendment, Second Amendment, Third Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment. We got the amendments for amendments, and right now, the only thing you really have here.
A lot of those Barnes arguments amazingly didn't seem to make it into the motion to dismiss.
Yeah,
Yeah.
they because they're
Barnes went
dumb
through a
arguments.
whole laundry list. First Amendment, Second Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, Seventh Amendment, Eighth Amendment. Man, a lot of those arguments didn't seem to make the cut. I wonder why.
Real. Isn't the argument that the cop could not have known the video wasn't altered, but told the judge he saw the original? Even though Gamble turned out to be right, it doesn't negate the misrepresentation. So,
That's fair. You can't get lucky. That is a very fair point. So just because the cop is proven right does not mean that the warrant was lawfully obtained. That's very true.
yes. So, what I'm saying here is that, is the argument that the cop could not have known the video was altered. Could not have known the video was altered. I'm saying, but told the judge he saw the original. Even so, I'm
I don't even
assuming.
think it's a I don't even think
I
it's
don't
a
know if
misrepresentation to say it's
I
the
don't know if
original.
he's here.
I just don't even think it is because it's exactly the same. It's uploaded somewhere else. It's like, oh, it's the original.
Uh,
Yeah, I saw the original. I mean, if you watch that video and you said to me you saw the original, I just don't think that that's really a material misrepresentation because it's digital, man. Oh, it has a it's not been edited to hell. It's not been distorted. It's not been chopped up, and it's intact.
if
It's
I
like
saw, all right,
call that original. I'm like, no, I'm not gonna flail you on that, man.
I'm saying, like, all right, I'll even make this argument. If I saw this video, if somebody say, "Hey, did you see Nick's stream last night?"
Yeah, and
and I
this is the
saw
video
this
you
video,
saw. I'm like, yeah,
I'm like, "Yeah,
you-
I saw," and they'll say, "Did you see the original?" Yeah, I saw the whole thing. I saw the original video. I
yeah.
wouldn't
That's
even
one
say
thing.
this is the original. And this is it's the whole thing. It's 4 hours and 4 minutes. It's all the same substance. Matter of fact, it's just the watermark. It's just the branding on the bottom right hand side that's different. Versus this video, which is on Nick's channel. Because then you
Yeah,
could also make the argument, which is the original? Is the one on Odyssey? Is the one on YouTube? Is the one on Rumble? They were all streamed at the same time. And matter of fact, this guy had either he made a copy of the recording, or maybe he streamed at the same time. For all we know, I don't know. I don't think this cop got lucky. I think he said he pulled the video down. He watched the entire
yeah.
video, and he presented the entire video. Now, the issue for me would be, did he see the entire video before? And if you can prove he did, then I think you're done. I think you're done. So let me see. Oh, hold on. I'm just looking at this. I merch. I want it. But I will say this about this document. It's put together a lot better than the last couple of documents.
Yeah.
It's easier to read too. And I will also say too, I think his lawyers have definitely stepped up the game because we're all reporting on it. So I think they stepped up their game to try to make something compelling. But make no bones about it, people. I want to make sure everybody understands this as if Nick loses this, he's freaking he's in tough straits. I don't want to say the word.
Yeah, well, I don't think, I still think that the most likely outcome of this is a plea deal or a diversion or something else. And even if he's convicted of everything currently on the table, as I've said before, he's not facing jail time. He's looking
Yeah,
at
yeah.
a suspended sentence and a couple of years of probation, which isn't fun, but it also isn't prison. So, and that's assuming that, he's found guilty as it lies. But, I still think a plea deal to a lesser charge, I mean, it's right on the boundary of third degree. So I think the state would probably pretty readily agree to a third degree or even perhaps a more favorable disposition or drug treatment or some other thing. So I think that, in terms of Nick is really hosed, I still think he has pretty good outs. It's not exactly the first time that someone's been found with drugs, not exactly the first time that someone, that's otherwise law abiding has been found with drugs. It's kind of routine and normal. So I imagine that there's going to be this isn't going to be a huge, I still the worst outcome seems less likely here.
Yeah, I think this case generally should have been plead out to maybe a light misdemeanor with some diversion program. You get what's
If
known
he
as
can get a
conditional.
misdemeanor out of this, he should definitely take it.
Yeah, and you get what's known as conditional discharge. Where you cop to the misdemeanor, you're a good person for like a year or something like that. You don't do drugs, then then you know what, that disappears. It's like it never happened. That's what they gave a lot of the Trump co-defendants in Georgia,
Yeah,
conditional
yeah,
discharges, and that's it, right? You plead to it. So I think that's probably the most likely scenario. I don't think he loses law license because if
no,
every lawyer who took cocaine lost their law license, then there would be a lot less lawyers, no, and judges and the whole nine. So I don't think that's going to happen. I think this is I like to call it a drama story. It has a lot of drama, right? The swinging aspect of it, the cocaine. Now the wife of the swinger now goes with Nick, and now he's arrested for sharing his wife's nudes. Like the whole thing is just like insano. But at the end of the day, this is a simple possession case. This is as
yeah.
simple
It's
as
a
it
simple
gets.
possession case, exactly.
Yeah, this is a simple possession case. And unfortunately, I think Nick is fighting for all of this. But I think at the end of the day, if he loses his motion, then he's back at square one and asking the state, what can he take?
Yeah,
That's essentially what you're looking at. What you look and and I think right now, I think Nick's got two big fears. One, he loses his motion. He loses his motion, it's over. He's got to plead. And then I think number two, the body cam footage. Because right now we're all living in this gray area where it's kind of like, is what the cops are saying true? Is what Nick is saying true? And I think the tiebreaker to all that is the body cam footage. When you see the body cam footage.
well, I imagine the body cam footage is going to show the house in some kind of state of disarray, and it's going to show the cops going to the places and finding the drugs in the safe and in the wherever they find it. It's going to prove the possession.
And
So I
and
mean, the body cam footage is going to tell a tale.
and things like Nick, like because Nick will say something like, because Nick is very good at this. He'll say something like, do you know what's in your house? Or, do you know everything that's in your house? Or, the cops never bring any, the cops could bring stuff into the house. And then when he's asked, like, oh, so you're saying the cops planted drugs? No, I didn't say that. But
Yeah,
he'll say those statements that kind of lead you to that point. And the issue I think happens is that you can't fool everybody all the time. And I think that's the problem. And I think here, and it's good that he has Barnes to push it, because Barnes is going to push corrupt cop, corrupt cop, corrupt cop. And the cop is sitting there like, yo, I just watched the video and gave it to the judge, right? That's what the cop is going to say. I just watched the video and gave it to the judge, but Barnes is going to be out there, corrupt cop, corrupt cop, corrupt cop. And I don't think that's helping, because I think at the end of the day, when he loses, or if eventually when he does lose this, I'm assuming, I think that's not going to be good for him, his family. And I think Nick needs reality, and reality is he's an addict. He's an addict, and he needs to be in a treatment program and needs to be getting help. Hopefully, I don't know. I haven't spoken to Nick. I don't know. Maybe he's doing that. But that's the reality of the situation, and he needs to put this behind him. And I know, being a internet personality like we all are, it leads you to want to protect whatever little credibility that you have. But I think sometimes, to protect that credibility, you have to kind of throw yourself on the sword and say, I've sinned. I'm infallible. I've made a mistake. Now let's, help me get past this. It happens to what's his name, Rush Limbaugh, right? He's caught with all those pills, blah blah blah. Cops are corrupt, but eventually he copped to it and said, "Hey, I was addicted to opioids," and now we have the opioid crisis, right? He was on the front edge of that, wasn't he?
Yeah, I mean,
So
it happens to people. Drugs are insidious, and they happen to people, and it's one of the reasons that just say no is a thing, because you can get out of control. So yeah.
I don't know everything in my house, but I know everything in my personal bedroom. Yeah, but I would know if there's 26 grams of cocaine. So, that's something I would know. That's something I don't know everything in here, but if there's 26 grams of coke, I would probably know that's in here, right? I don't think you could just put it there. Matter of fact, April, her credit cards are on the coke. How bad luck is that? Like, could they not find something else to chop the coke up? Like, they're going to use credit. April, let me get your card real quick.
They use her own current valid credit cards too, which is a nice touch.
Like, let me use your credit. That one's good, right? The one, this is the one you're using right now. Chopping up the coke, spread those lines. Boom, cops come in. Now your credit card is all up and mixed up in the coke.
Well, we learned something about drug safety, my friends. If you're going to use things, try not to make them things that are branded.
Yeah, like how do we know this is her coke? Because like all her credit cards and wallet was right on top of it. Wow. So what do you think this means for? So our prediction: this should be dismissed. If not, he's going to
Yeah,
lose
and
the
of
Frank
course, whatever's true for Nick would presumably be true for Kayla, because their issues are identical, right? The reason we got into the house is the exact same search warrant, so their issues are tied together. So if it fails for Nick, it fails for Kayla for the exact same legal reason. There's no reason to think there'd be a different outcome. And also fails for April, because again, the reason that we got into the house is the same thing. So any motion there would be, it also fails for April. And so you're looking at, and in terms of April's charges or the lack thereof, not really, we haven't seen a lot from her yet in terms of that, but it looks like they're just doing because we found the drugs on the cards, that's possession, which is more easily fightable than in the home, because that's more constructive possession when it's in your own home.
Yeah, and that's why she got the lighter coke charge too, because they were saying we can only charge her who was which was on her card versus everything in the house. So and then they have what's that combined, like that constructive possession where everybody is now, they charge everybody with possession. It's
well, it's one of the joys of being married, right? Everyone knows everything collectively.
Yeah.
There's that too.
Well, she's a third party, so
well, yeah, I was speaking about the wife specifically, but yeah. And then of course for Aaron, I still think he probably has options at a plea deal. The harassment angle isn't necessarily readily the most obvious. I mean, I think you can probably prove it, but it might take some work. So a plea deal for him to a gross misdemeanor seems likely. But I think if Nick can get out of this, and Nick and Kayla can get out of this with a misdemeanor or a judgment, deferral in favor of, in view of acquittal, if they can get out of it that way, they should leap at it all day long.
Oh yeah.
That's what I would do. I would leap at the misdemeanor, or I leap at the deferral in favor of dismissal if I can get out of that. So
we have those 4 people in that hot tub. Right now, we're predicting all 4 of them have
all
to
4 are
plead
charged
guilty,
felons. It's not going great, man.
and they all have to plead guilty, because I'm thinking Aaron, they got him dead to rights. Just watch little people.
They've got him dead to rights on the misdemeanor.
Yeah, they got him dead to rights.
I mean, I saw it happen with my own eyes.
Yeah, they got him, like, he literally got him dead to rights. So I think he's done. He's got to plead to something.
Who would have ever thought that an allegedly swinging relationship might have ended in tears, though?
Yeah, this badly. April, I think I think is in the toughest spot, because she could easily flip and say that's not my coke, and I was just there.
Oh yeah, no. If I'm April,
witness, right?
I'm like, how would you like my testimony?
Yeah,
in exchange for a walk.
Yeah.
Sounds real good right about now. Yeah.
And said because you could fight her on the possession, but she could say, "I gave her my card," and I didn't know
Yeah.
what the fuck she was doing with my
Yeah.
card,
Yeah. How
right?
would you like my testimony exchange for a walk is really good for April. Because it's like, yeah, I use drugs. I used it with them all the time. Here's where the drugs were. I get a walk. Yeah, that's April's best deal.
Yeah, yeah, yeah.
So
I think, I think that she could easily get that because don't forget, just because she was now, even though you could make the argument she's in the home, she's been living there for X amount of time. She probably you'd have to be a dummy not to believe that she doesn't know that there's coke all in the house. She's probably even using some of that stuff, but I wouldn't. I would think that she has the best chance of fighting it and getting a straight out win. I think
yeah,
she has the best chance of getting a straight out win out of all of them. So April, I think she can make the argument that wasn't mine. I gave them my card. They did whatever with it. I was just a friend of the house. They were doing coke in their bedroom. I'm not in their bedroom. That type of thing. You know what I'm saying?
sure. Of course, if this does go to trial, we're very likely to hear details about their relationship because it's probably going to come up
I
as we're
think
trying to talk about their if April takes the stand or Aaron takes the stand, their relationship becomes a factor of their bias.
yes.
So I imagine we might hear further tales under testimony about their relationship to some degree. So there's that factor too.
I think that's more. I think that would be more relevant in the other. Well, I think in April's case it would be relevant because why the hell is she there, and how you make the argument that the coke is hers and she was there. So I think you make that argument with her and Aaron about the relationship. I think it becomes highly relevant for her. I think for Aaron it's extremely relevant because that's essentially the whole case. He's sharing Nick's wife's nudes. How did he get the
How did you come
nudes?
into possession in these photographs in the first
Oh, I
place,
was
Aaron?
sending it to him. You were singing to
Uh-huh.
him.
Why was that?
Now we talk
Why were they
about
sending it to you, Aaron?
yeah.
Would you like to
Why is
talk
he
about that at all?
now
Oh
we start
Lord.
talking about the
Yeah.
relationship and all that other stuff, and okay. So you guys were together, but not together like then you got so I think that child services, I'm glad he got his kids back. So this has just been a mess. And still toe is back on it. They're still back. He's back on spewing his nonsense. But I think at the end of the day, this is just really, and I think people really just need to put this in perspective. This is just a simple possession case. He probably
This is every day.
yeah. This is a
This is
simple
every
possession
day. I
case.
think one of the things that people are sometimes failing to contemplate when they're trying to say, well, that the states, or problems with the affidavit or problems with this. It's like I think one of the things that people who are looking at this in a more favorable light to Nick, somewhat are underappreciating, is that this is just every day. Drugs
Yeah,
are every day. They're every day. And the cops and the police and the prosecutors do drug case after drug case after drug case after drug case. And it's just noise. It's noise. And so, in order to overcome just the banality of it all, and the routineness of it all, in order to really, make the the court sit up and really take notice, you have to really do something that's truly extraordinary. The cop really has to screw up in a serious way to really sort of do that, to make it just not like, okay, just stamp the form, move on to the next thing, stamp the form, move on to the next thing. It's like maybe that shouldn't be the way it is, but it is. And so
yeah.
this is just paint by numbers. It's another day that ends in Y. And so trying to pick it apart in these little details is probably not going to be the thing that succeeds.
No, well, again, right now it's not over. Right now,
It's not over. The judge could always
I
disagree with me.
I would say
Judge could disagree with me.
since
Hold
it's
their Frank's hearing.
since right now we're in football season, I'm saying Nick is down by 14. We got like 3 minutes to go, and the defense, he doesn't even have the ball. The other side has the ball, so he needs to get the ball back and score twice to tie the game. Now, is it possible? Yes,
It's possible.
but is it
It's possible
likely?
if the judge really latches on to that failure of the cop to note the dismissal or the lack of probable cause determination from child services. If the judge really latches onto that, let me put it to you this way: if the judge is looking for a legal reason to dismiss, they have one. So if the judge is looking for a legal excuse to get rid of it, they can. So you got that going for you.
Yeah, I do think. I think the judge. But this because if you're the state, you may have to appeal something like this now, because it would be on such shaky grounds, because you have so many cases. Because don't forget, a lot of people think the criminal justice system has to be perfect, right? This I wasn't. That's essentially what you have here. This I wasn't dotted. This T wasn't crossed. That type of thing. But it's not. It's a really. It's a messy system, and it's just about how messy. And that's why in the Frank's test it says it has to be intentional, intentionally trying to deceive, intentionally doing this, intentionally doing that, and if you give the judge the full video and the full context, but you just didn't get it from this, you got it from spot A versus spot B, and you give it to him, and it's all the same. I don't know if you reach that point where you're saying this the cop is materially trying to mislead the court. I just don't. I don't think you're there. So, but we'll see. We'll see. I've been saying this for the past couple of months now. I think the best option would be these cases be dismissed. Nick goes into a treatment program, gets his life back together, becomes the Nick that we knew 5 or 6 years ago. But right now that doesn't seem to be likely to be the case. So, Kurt, tell the people what you got coming up. So let's get out.
Yeah, we got a lot of cool stuff coming up on my channel in the near future. We got one dealing with this TikTok. How about would you like free money from the bank? That people have been talking about in the news. Didn't really work out for a lot of people. Coming up,
indictments.
We got a story dealing with the Google incognito mode story that's coming out pretty soon. As soon as I get the link that's valid for that, I want to post that story. And then we got some other edited stories that are coming up in the near future. So make sure to check them out. Try to go it every day. We're going to post one here in about an hour. And so make sure to check that out, and hope you check it out here on Uncivil Law. Should be fun.
Yeah, this week we got a hell of a week coming up. We got the Super Mayor saga. We got another. So this week, the trustees.
Find out what my editor posted for me today.
We got the trustees.
I haven't even looked yet.
What's it? The trustees they have a meeting because last time the Super Mayor didn't put their stuff on the agenda, so they're having their own particular meeting. So we got that coming up. We got I got a couple of Nick Rekieta videos coming up, but I don't even know if I'm going to post them. I just might make them members only. We also have this judge who was fired for extreme racism. We had like a lot of judges fired for extreme racism in Michigan, so I'm doing that story. I'm also doing another story about did you see what's going on in New York City? The FBI's raiding the police commissioner and all the top people.
I missed that one.
They've all been raided too. So yeah,
really?
So we got a lot. Yeah, in New York. As a matter of fact, yeah, I'll pull it up. I was watching it this
Wow.
morning.
No, I missed the FBI raiding the police in New York story. That's good times.
NY police commissioner raided.
That should be a good story on a Law and Order episode.
Here it is. Check this out.
News. Federal agents raid the homes of 4 top aides to Mayor Adams, entangling his administration in yet another investigation.
Sources say the raids targeted the homes of Deputy Mayor Sheena Wright and Schools Chancellor David Banks, who lived together, his brother, Deputy Mayor Philip Banks, and Police Commissioner Edward Caban. Political reporter Marsha Kramer live at City Hall, where she just spoke with the mayor.
That's crazy. That's what I heard this was coming. Yeah, but that's crazy. So New York's got some craziness happening in New York.
Corruption in my New York Police Department? Whoa. Never heard about that before.
All the way up. Oh, and also, I have the first transgender mayor got kicked out, got thrown out of office for corruption in California, which is hilarious. So we got a whole bunch of those little bit tidbit stories. 10 uncivil law memberships gifted. So hopefully, if you guys like that stuff, we got them coming on. I've been running a little slow lately for this getting out content, but I think we've got things back on track now. So with that being said, don't forget, like, share, subscribe to both our channels. I'm here with Uncivil Law. Let me know in the comment section, what do you think? What do you think Nick's chances are? I will say this, I think his chances are slim, but we can hope for the best, but plan for the worst. As always, don't forget, like, share, subscribe, do all that great YouTube stuff. My name is Nate. That's Kurt. We'll see you next time.
Later. Bye.